Welcome to this explainer. Today, we're unpacking a sort of legal superpower. Have you ever wondered how to hold corporate polluters liable before any major modern statute even applies? We hear so much about big federal agencies, but if you, or even a local regulator, need a way to immediately defend your property or your health, the tools you need have actually been hiding in plain sight. We're talking about centuries-old English common law actions.
Let's quickly run through today's agenda. We'll start with the original environmental law, cover the three theories, nuisance, negligence, and strict liability, compare them, and then wrap up with the bottom line.
Starting with Part 1, the original environmental law.
Picture this. A factory opens up literally right next door to you. Almost overnight, it's billowing thick smoke, making an absolute racket at all hours, and just generally emitting noxious odors. You might think your only recourse is to beg a federal agency to step in and save you, but you don't actually have to wait. Centuries-old common law principles allow individuals and regulators to bypass the bureaucratic red tape and take direct action against business polluters.
So, it really begs the question, under what specific common law theories can you actually hold these polluters liable? How do you categorize the harm so a court takes you seriously?
Well, it comes down to a three-part toolkit: nuisance, negligence, and strict liability. Each operates totally differently, and each requires its own legal strategy.
Let's pull out our first tool. Theory 1, nuisance.
Under the doctrine of nuisance, if a business creates dirt, smoke, or noise that unreasonably interferes with your right to use and enjoy your own property, they can be held liable. Unreasonably is the absolute key word here. You have a right to enjoy your property in peace, so when a neighbor actively disrupts that, you've got grounds for a private nuisance lawsuit.
But there's a catch. Courts use a pretty strict balancing test to decide these cases. They don't just look at your suffering in a vacuum, right? They carefully weigh the harm caused to you against the pure economic cost of stopping the pollution. It's this massive tug-of-war between individual property rights and the community's economic benefits.
Let's look at a classic example. Say Hewitt's Gravel Company causes terrible noise and excessive truck traffic for its neighbors. But Hewitt's is also the beating heart of the local economy. Because of that balancing test, a court might actually refuse to shut the company down. The economic blow to the town would just be too great. Instead, they might force the company to pay you monetary damages to make up for your decreased property value.
Moving on to Theory 2, negligence.
Now, if nuisance is mostly about balancing property rights, negligence shifts our focus entirely to fault. You have to prove that a business failed to use reasonable care, and that failure resulted in a foreseeable injury. Imagine a factory that skips installing industry-standard air filters just to save a few bucks, and, as a direct result, the neighbors suffer respiratory illness. Because that illness was foreseeable and the factory lacked reasonable care, they're negligent.
And this introduces a rapidly growing super high-stakes area of negligence known as toxic torts. These are civil lawsuits that stem directly from exposure to hazardous substances. Think asbestos, radiation, or toxic waste. If a company fails to protect you from those known dangers, a toxic tort is your main legal weapon.
Which brings us to Theory 3, strict liability.
What if the business was being perfectly careful? What if they followed every single safety protocol, but the activity is just incredibly dangerous by its very nature? Enter strict liability. This applies to businesses engaging in ultra-hazardous activities. A classic example is the transportation of radioactive materials right through a residential town. It honestly doesn't matter how many precautions they take, the baseline risk of catastrophe is just astronomically high.
And here is the absolute game changer. The injured party does not need to prove the business made a mistake. You don't have to show they lacked reasonable care. If their inherently dangerous activity causes you harm, they are automatically, strictly liable. Period.
Section 5. Comparing the three theories.
Let's look at a side-by-side comparison of these three common law theories that let a neighbor or a regulator hold a polluting business liable. If your property rights are compromised, nuisance is your avenue, subject to that economic balancing test. If you've suffered a foreseeable injury because a company was careless, negligence is the tool for you. And if you're harmed by an ultra-hazardous activity, strict liability is triggered simply by the hazardous nature of the act itself.
The most massive difference here boils down to the burden of proof. For negligence, proving fault is mandatory. You must show they messed up. But for strict liability, fault is completely irrelevant. That distinction totally dictates your legal strategy and the kind of evidence you're going to need to win.
Finally,
Section 6. The bottom line.
We've covered a lot of ground today, but why does this matter to you? Well, while sweeping federal statutes like the Clean Air Act are obviously vital for national regulation, they aren't your only path to justice. These three common law theories remain highly effective tools that private citizens, local property owners, and regulators can leverage independently, even before any big modern statute applies. They put the power directly back into your hands.
The reality is, you can't always wait around for the federal government to step in when toxic smoke is blowing into your backyard. So my question for you is, statutes are powerful, but if a polluter threatens your peace tomorrow, are you ready to use the common law to protect your community? Thanks for joining me for this explainer. Stay curious and stay empowered.